Determine the semester of contingency. Contingency means natural delivery, miscarriage, or cesarean section. How do you spell cesarean?
CA.
C-A-E-S-A-R-E, not I, R-E-A-N. Sometimes C-E only. Okay. Determine the semester of contingency. Example, nanganak, March. So, what is the sem of contingency? First semester, di ba? Then, you count 12 months backwards from the start of the semester of contingency. 12 months backwards. During this period, look for two things. Number one, 3 monthly contributions. Meron ba? Kung meron, tapos she complied with the reportorial requirements, bigyan mo. Okay, how do you compute? Okay. You look for the 6 highest AMSC, average monthly salary credits. Look for the 6 highest monthly salaries, and then you add them. Add the 6, 1 plus 2 plus 3 plus 4 plus 5 plus 6, and divide the sum by 180 days to arrive at average daily salary credit. Yes, again, I repeat. Look for the 6 highest average monthly salary credits, add them, divide the sum by 180 days to arrive at average daily salary credit. Then you multiply it by 100%. Okay, result to be multiplied by 60 days if normal delivery or miscarriage, or 78 days if cesarean section. That is how you compute maternity benefits. If you are asked to compute sickness, mag-iba yung figures mo. The same, you determine the semester of contingency. Kailan ba siya na-confine? Kailan nagkasakit na-confine? Okay? You use the term confine. Confinement may be at home or in a hospital. Kailan ba siya na-confine? Dito, January. So the semester of contingency is first sem. Again, you count 12 years back from January, which is the start of the semester of contingency. Look for 3 monthly contributions. Look for the 6 highest monthly salaries. Divide it by 180, okay, to arrive at average daily salary credit times 90% this time. Kung sickness benefits, 90% ang multiplier mo. Okay? Times number of days of confinement. Number of days of confinement. You think you can remember this next week? Can still remember this next week? Next month pala. Ito na siguro yung pinakamahirap sa SSS. Otherwise, kayang-kaya ninyo. Kayang-kaya ninyo. Pakaibigan na naman si Anwed Ma'am, si single mom. Other benefits, you will not be asked to compute them. Okay. Contributions. The basis of the percentages is compensation, not salary. Okay, not salary, but compensation. So as between the two, compensation is broader. Number 2, difference between SSS and EC, Employees Compensation Act, or AREC, Amended Rules on Employee Compensation. Who pays SSS contributions? Both employer and employee. Who pays EC contributions? Only the employer. Only the employer. So, ganun ang difference. Next. Condonation. This is a decision of your chairman, Justice Benedict G. When is an employer entitled to condonation? Number 1, when he has fully paid the delinquent contributions. When he has fully paid the delinquent contributions. In the case decided by Justice Del Castillo, there was partial payment only. So sabi niya, you are not entitled to condonation. It has to be full payment of the delinquent contributions. Kung walang payment, kung walang full payment, at least the employer must have submitted a proposal for payment. Proposal for payment. Those are the conditions of condonation. Next area, penalties. So 8282 is a penal law. It is a penal law. First point, is there a need for prior SSS consent before an employer can be criminally prosecuted under 8282? Supreme Court said no need for prior SSS consent. Number two, double jeopardy. Okay, no double jeopardy if an employer is prosecuted, okay, under 8282 and under the RPC for STAPA. And you know why there is no double jeopardy in that case. So those are the possible questions, if not possible sources of questions relative to SSS. Let's now go to GSIS. It will be compensation rules like the corporate doctrine of Dean Bokis. By the way, this will be a lecture without boundaries. I'm supposed to tackle standards and subject, di ba? But time and again, I will invade the territory of Dean Bokis. And we have no problem with that. We have been doing it all these years. Wala akong problema. Some lecturers ayaw na invade yung territory, di ba? So yung corporate doctrine niya, akin yan eh. Pero pinasok niya, di ba? Walang problema. Pero I will tell you more about his cobra. I am sexy. Says who? Dean Bokis. I am sexy. After making that statement, what is the question to ask? How? How? I have a beautiful body, period. Question to ask is where? Where is that body? Answer, I hid it, period. How? With some facts. With some facts. Question to ask after that is why? This is the Alcantara method, huh? With my facts. Why? To protect my sexy body from Dean Bokis, period. Question to ask after that is who? Who else? Not McFarlane, something. So that's how you ascertain the completeness of your answer. Keep on asking and answering questions. Okay? You practice tonight, and you practice. Basta practice. It takes practice. So after anong date na ngayon? October 2, no? You stop reading na. After this lecture, you stop reading. You start exercising. You imagine questions and you answer your imaginary questions. Practice crafting your answers. Don't think that if you know everything, you will pass the bar. I don't think so. You practice formatting. Okay, formatting. Make your notebooks pleasant to the eyes of the examiner. That's a technique. Coverage of GSIS. So all employees in the public sector, whether appointed or elected, who receive basic salary. Appointed, elected, who receive basic salary. So don't give coverage to a government employee whose income is limited to per times or honorarium honoraria. Okay. Wala silang GSIS coverage. And must not be more than 65. Must not be over 65. Kung SSS, not over 60. Which means that the employee has not yet celebrated his 61st birthday. Yun ang ibig sabihin not over 60. GSIS, not over 65. So logically, he has not just celebrated his 66th birthday. Yun ang ibig sabihin, not over 65. And employer-employee relationship for purposes of GSIS is determined with the same rule, the fourfold test. The fourfold test. It will be rules on compensation. So a GSIS member would be rendered incapacitated or would be killed by either injury or disease. So member will be disabled or would be killed, dead by either injury or disease. So the issue to resolve would be compensability. Okay? Is the member entitled to disability compensation? Are his beneficiaries entitled to death compensation? Yun ang tanong. When the disability or death is caused by disease, okay, it is compensable if that disease is an AOO disease. It arose out of employment, which means that it is an occupational disease. And how do you know that a disease is occupational? It is a listed disease. So the list to consult is Annex 8 of the Employees Compensation Act, which is now Annex 1 of the Amended Rules on Employee Compensation. Annex 1. So kung nakalista yan, it means work-connected or occupational. And therefore, the resulting disability or death must be compensable. Now, what happens if the disease is not listed? In your seafarers rules, no? POEA-SEC, there is a disputable presumption of work connection for unlisted diseases. But here, there is no such disputable presumption. Therefore, the claimant is required to prove work connection outside Annex A or outside Annex 1. And how does he do that? With substantial evidence. With substantial evidence. And he has at his disposal two tools, okay, to prove work connection outside the list. Number one is the proximate cause theory, and the second is the increased risk theory. How does the first work? Proximate cause theory. In the case of Bellarmino, a school teacher, public school teacher, was killed by an unlisted disease, okay? Namely postpartum septicemia. And because she was killed by an unlisted disease, GSIS denied the death claim. Supreme Court allowed the claim. Why? Because the facts of the problem indicated that there was a chain of causes connecting performance by the public school teacher of her work and her death. Supreme Court in that case applied the proximate cause theory. So ganito niya ginamit. She was a public school teacher. She was dedicated. Because of that, she went to class every day. One day, she slept on the floor of her classroom, and she started to bleed from that accident. Co-teachers advised her to take a leave of absence, but because of her dedication, she continued to go to class until it was time for her to give birth. She was pregnant then, and nag-bleed. Okay? Because she was a poor teacher who could not afford the expensive services of a hospital, she had to give birth at home where conditions were not clean, were not sanitary. And because of that, she contracted that infection which killed her. She contracted that unlisted disease which killed her. So what did the Supreme Court see in the case? A chain of causes connecting performance by the teacher of her work and her death. And that chain was unbroken by any efficient intervening cause, like notorious negligence, intentional attempt on against one's life or against the life of another, and intoxication. Wala. None of the three was present to break the chain of causes. For that reason, applying the proximate cause theory, the Supreme Court allowed the death claim. What about the increased risk theory? How does it work? So again, a member is killed by an unlisted disease, like glomerulonephritis. Glomerulonephritis, however you spell that, however you pronounce it, does not matter. What matters is it is not a listed disease. And it killed a government employee. And because the disease was not listed, the death claim was also denied by the GSIS. But the Supreme Court allowed the claim. Why? Okay, applying the increased risk theory, the Supreme Court saw that the disease was work-connected. It was occupational. So how did that IRT work? The member was a government physician. For 20 years, okay, she performed her work as a government physician, exposing herself in the process to all kinds of bacteria, including Streptococcus bacterium, which was the cause of streptococcal infection, which in turn was the cause of glomerulonephritis, which killed her. Okay. So the question to ask is, did performance by that doctor of her work increase her risk of contracting that unlisted disease? Did the performance by the member of his or her work increase his risk of contracting that unlisted disease? If the answer to that question is yes, you allow the claim. Otherwise, you deny it. In the case of Dr. Garupa, the Supreme Court's answer was yes. The performance of that doctor of her work for 20 years increased her risk of contracting that unlisted disease called glomerulonephritis. What if the disability or death is caused by injury? Injury. To be compensable, that injury must be an eco-injury, in the course of employment injury, which means that the injury was sustained at the member's place of work while performing his work. At the member's place of work while performing his work. What if it is sustained outside his assigned place of work while ministering to his personal comfort? Pasok si Cobra Doctrine ni Tim Pokis. What happened dun sa kwento niya? Nag-jingle si Tim Pokis, sila. Sarado yung mga CR sa UST. So, assuming gobyerno ito. So, he had to look for a place to make jingle. He went to the perimeter fence, grassy. Then started to do his thing. May cobra pala behind the grass. Nakita niya, uy, kalaban, naka-helmet. Tinuklaw niya. Tinuklaw niya si Tim Pokis. How many times? 2. Tuklaw, tinuklaw. Okay. So, na-disable na ngayon si Tim Pokis na claim, denied. Why? Because he sustained his injury outside his assigned place of work. Pero compensable yung disability niya under the COBRA doctrine or under the personal comfort doctrine. Okay. Now, that doctrine, personal comfort doctrine, is now subject to 2 qualifications. Okay. For the resulting disability of the death to be compensable, the injury, the off-premises injury, must have been sustained within the space limit and within the time limit of the member's employment. So, magic terms, key phrases, within the time limit of employment and within the space limit of employment. Which means that if the Pokis was on 8 to 5 work shift, the tuklaw must have happened between 8 and 5 to be within the time limit of his employment. Okay. Saan siya natuklaw? Doon sa 10 kilometers away. Okay. Disability not compensable because the injury was sustained outside the space limit of his employment. So please take note of these 2 qualifications of the personal comfort doctrine. The Employees Compensation Commission has come up with several new rulings. So, before we go to them, let's first review decided cases involving soldiers and policemen who died, and therefore issue in each case was whether or not their death was compensable. In the case of Hinugin, the soldier's place of assignment was Nueva Ecija. Place of death, Nueva Vizcaya. Why was he in Nueva Vizcaya? He asked for permission from his commander to travel from Ecija to Vizcaya with his fellow soldiers. When they were in Vizcaya, somebody, a fellow soldier, accidentally pulled the trigger of his M16, killing the soldier. That's been filed, denied. Why? Because the soldier died outside Ecija, his assigned place of work. Supreme Court said that was compensable. Why? Because his presence in Vizcaya was under authority of the night pass issued by the commander. Night pass. So in compensation cases, expect to see places, two places, place A and place B, where A is the assigned place of work of the member and B is the place of contingency, place of death or killing, okay, or injury. A member will be absent from place A, present at place B where he is killed. So the issue to resolve is compensable ba yung death niya? If there is a reasonable causal connection, if there is a reasonable nexus connection between absence and presence, you give compensation. Otherwise, you deny compensation. In other words, you are going to apply the reasonable nexus rule. Ito ang gusto makita ng examiner. Reasonable nexus rule. Is there a reasonable connection? Nexus means connection between absence from assigned place of work and presence at the place of contingency. If there is, you allow compensation. In the case of Hinugin, place A was Ecija. Place B was the place of contingency, Vizcaya, where he got killed, di ba? Was there a reasonable connection between the two? Okay? Supreme Court said, yes. What made the connection reasonable? The night pass issued by the commander. The night pass. In the case of Nitura, a soldier was killed also. How did he die? Commander dispatched him to look for his fellow soldiers who went to attend a dance party. To reach the other place, okay, he had to cross a wooden bridge. When he returned to camp, he crossed that same bridge, but this time he fell off that bridge and died. That claim filed denied. Why? Because he died outside camp. Supreme Court said that was compensable. Why? Because he was authorized to travel outside camp. Number two, a soldier is deemed on 24-hour duty. Okay? A soldier is deemed on 24-hour duty. Because of that 24-hour duty rule, there will always be a reasonable connection between absence and presence. Okay? It doesn't matter what a soldier gets killed. If he gets killed on top of his military truck, his death is compensable. If he dies on top of his paramour, death is compensable. Why? Because he's deep on 24-hour duty. He is performing a duty. The 24-hour duty rule is now known as the Markman rule. Markman rule. So explain the Markman rule. 24-hour duty rule yan. Okay? But tell the examiner that a soldier, a policeman, is deemed marked for liquidation. Deemed marked for liquidation. That is the presumption of law. So it doesn't matter where they get killed. Deemed marked for liquidation. In the case of Alvaran, a soldier shot another soldier to death. Place of assignment, Pasig. Place of the killing was in Muntinlupa. Why was that policeman in Muntinlupa? He accompanied his son because he was being investigated by the policeman, by the police of Muntinlupa. in Muntinlupa, he had an altercation with Muntinlupa police who shot him to death. That claim filed denied by the GSIS. Why? Because according to the GSIS, that policeman was in the performance of a purely personal duty at the time he was killed. Supreme Court said that was compensable. Why? Because that policeman was not performing purely personal purely personal mission, but peacekeeping mission. I'm so focused on key terms kasi na. Okay. Peacekeeping mission. Why peacekeeping mission? He accompanied his son so that his son could be investigated for his alleged participation in a crime. That wasn't a purely personal mission. It was a peacekeeping mission. So back to the question, what makes the connection between absence from Pasig and presence at Muntinlupa reasonable? Okay. Performance of peacekeeping mission. But in the case of Alegre, the Supreme Court saw performance of a purely personal mission. On that basis, it did not allow compensation of the policeman of the death of a policeman who was shot by another policeman. What happened in Alegre? Place of assignment was a certain police precinct in the south. Instead of manning that police precinct, the deceased ferried passengers around town on his tricycle, collecting fares from them. Nainis yung kasama niya police, binari niya outside the precinct. Death claim filed, denied, Supreme Court said denial proper. Why? Because at the time of the death of that policeman, he was in the performance of a purely personal mission. Purely personal mission. Your 24-hour duty rule, Markman rule, admits of an exception. If the policeman or soldier is on official leave of absence and he gets killed while on leave, do not give compensation. That is an exception to the 24-hour duty rule. So that in the case of De La Ria, a soldier was on leave while alighting a passenger jeepney. He was shot to death with a .45 caliber. Supreme Court said death was not compensable because the case was not covered by the 24-hour duty rule because the policeman was on leave of absence. So that is the exception. Now, how do you treat evidence in compensation claims? Of course, you look for substantial evidence only, okay? Substantial evidence only. Now, in the case of Rodrin, the GSIS member was an intelligence officer. One day, he received a mission order from his superior to arrest certain criminals believed to be hiding at place A. On his way to that place, he received reliable information that those criminals had relocated already. So based on that information, he had to change route. And in order to reach place B, he and his group had to pass through a private subdivision. At one of the gates of that private subdivision, he had an altercation with a security guard who shot him to death. Okay. That claim denied. Why? Because he died outside the place specified in his mission order. Supreme Court said that was compensable. So I take note, he received reliable information, and on that basis, he had to change route in order to reach the second place. Rule is, whenever there is doubt arising from evidence in compensation cases, you are going to resolve that doubt in favor of the member. Why? Supreme Court said in Rodrin, because the purpose of social legislation is to give and not to withhold. The purpose of social legislation is to give and not to withhold compensation. Now, what is the continuing act rule? Continuing act rule. A is the member's home, B is his place of work. In between the two places, he sustains an injury resulting in his disability or if not death. Is his disability or death compensable? Answer, it depends on the distance, okay, between the contingency and his place of work. So before we measure distances, we spoke of proximity. We spoke of proximity. Under the continuing act rule, we do not measure distances anymore. We do not speak of proximity anymore. Why? Because the law presumes that the member's act of leaving his house, his act of traveling to his place of work, his act of leaving his place of work to return home are continuing acts. So it doesn't matter where the injury takes place. We do not measure distances anymore. Subject, however, to two exceptions. Number one, unreasonable diversion rule. Number two, unreasonable departure rule. So Dean Pokis leaves his house to report to the Supreme Court. Supreme Court, hindi na sila GSIS members, di ba? Gawin natin NLRC, hindi rin eh. Gawin natin basta government office. Dean Pokis leaves his house to report for work. Instead of going straight to work, he fetches his GF and drives her to her own place of work. At the drop of point, Dean Pokis is shot by who? The husband of his GF. His disability will not be compensable. Why? Because of the unreasonable diversion. Unreasonable diversion. He leaves his place of work to go home. Okay? Palitan natin, hindi na si Dean Pokis. Let's make that Joaquin. Instead of going straight home, he participates in a shabu session. Natukhang, nanlaban, pinatay. Death not compensable because there is unreasonable departure. Unreasonable departure. So, those are the compensation rules that you can apply to solve or answer compensation problems. Okay. What is limited in the law? What is portable in the law? If your girlfriend is very obedient to you, you tell her, let's go there, she goes with you there. You come, she comes. You sit, she sits. You eat, she eats. Then she must be a portable girlfriend. Why? Because you can bitize her anywhere you go. Under the law, limited portability law, what can be bitized? Two things. Number one, length of service, and number two, contributions. Meaning, as a member moves from one system to the other, SSS to GSIS or GSIS to SSS, he carries with him, number one, length of service, number two, contributions. Kaya portable. What is limited in the law? Bakit limited portability law? The law has a totalization provision. Totalization provision. Under which length of service under SSS can be added to length of service under GSIS. When is totalization permitted? When a member is disqualified from a benefit, no? From being entitled to a benefit by reason of lack of length of service. So galing siya SSS. Okay? Pumasok DOH, so GSIS siya. To be entitled to retirement benefits under GSIS, kailangan meron siyang 15 years, something. Meron siyang ilan? 12. So he needs 3 more. He can get the additional, the deficiency from SSS. But for that limited purpose only. For the limited purpose of allowing him to qualify and nothing else more. So, justification for totalization, disqualification by reason of lack of length of service. Okay. reason for the totalization in order to enable the member to receive benefit. In the case of Gamo-Gamo versus PNOC, Gamo-Gamo joined DOH, so GSIS, no, in 1963 as a dental aide. 67, he was promoted to the position of a dentist 1. After 14 years of work with DOH, he decided to join the private sector. So he resigned, joined Lucevico private company. Later on, Lucevico was absorbed by PNOC. At one point, PNOC floated a retrenchment program which guaranteed payment of separation pay consisting of 2 months' salary times length of service. Dr. Gamo-Gamo applied for retrenchment, but his application was denied. So he continued working for PNOC until he retired. And when he retired, he was given his retirement pay consisting of 1 month's salary times 70 years of service under PNOC. So he went home with over $500,000 by way of retirement benefits. While in retirement, he discovered that 2 of his fellow co-workers were given 2 months' salary times length of service under the same retrenchment program. So he got upset. Gamo-Gamo, galit-galit. That's why the title of the case is Gamo-Gamo versus PNOC. What did he want from PNOC? Give me 2 months. Okay? You add my 14 years with DOH to my 17 years with you. Because 31 times 2 months salary was so much less whatever you have paid me, invoking the limited portability law. Supreme Court said, totalization is not allowed. Totalization is allowed under the law only if a member is disqualified from availing of retirement benefits by reason of lack of length of service. In your case, Dr. Gamo-Gamo, you have the requisite number of years to be able to get retirement benefits from GSIS. Kasi nung araw, kung may 3 to 14 years ka, pwede ka na. Okay, pwede ka na. So, if you want to go back to GSIS, claim your GSIS retirement pay, after all, it does not prescribe. It has no prescriptive period. So that is your Gamo-Gamo versus PNOC. So with that, I believe we have covered important points on soft leg. We are now ready to jump to labor principles. Do you want to go on the break? How many minutes? Sige na, para alam namin ang bibigay namin. We want J. Del Castillo decisions, di ba? Okay. His decisions are not really scary. Mainstream siya, mainstream. May mga exciting decisions siya like Orchard case and Lim case, which you will take up later on. Otherwise, his decisions are mainstream, repetitions of old doctrines. Take note that some of his decisions involving seafarers have been modified already. So if you have that compilation of J. Del Castillo cases, we will be very, very selective. Okay, I will just invite your attention to rulings which are still good up to this day. The rest, medyo set aside natin. Yun ang problema when you keep on reading material sourced from questionable sources. Ito yung mga ginagawa ng estudyante, di ba? Di naman sila marunong pa eh. So, do not read everything that comes your way. If you know 60% of labor law only, do not panic. You can still become a lawyer as long as madiskarte ka, as long as you know how to present your answers. So if you have not read several laws, go take the bar exam. You are not the final judge of your performance. Who knows your notebook will not be read anyway. You will just be given an automatic 99. Imagine that is what is meant by overdue process in the bar. Kasi nanalo ang Blue Eagles, for example. Is examiner mo, Atenean yan, Atenista nila. Nanalo si Blue Eagles. Okay. Excited, happy siya, di ba? Tamang-tama, chinecheck niya ang notebook mo. You think he will fail you? I don't think so. Oh, those are the human factors. Kung natalo, tinalo ng UST. Grabe. So, sad siya, galit siya. What do you think will happen to your notebook? Sorry na lang, under due process siya. Let's come back after 5 minutes.